John Legg, as Andrea's mentioned, John Legg here from Chicago, doing this remotely. This is our second, well, this will be our third tournament with the Arizona Bar Foundation for the mock mediation for the high school level. And now we're extending it also to the middle school level. So with your cooperation and assistance and help, and we get bigger and better each and every time. So thank you, Andrea. Real quick, remember we overview is our third session out of the 5. The first one, overview of the mock mediation, so you sort of get a big picture of how a tournament, again, 2 purposes. One is the general education on mediation itself. The second thing is the scenario for the competition in the high school, middle school levels. So how the layout of the rooms, how the parties are presented, and the basic layout of the mediation. And then we did give some materials handed out. So there is one case, you can read that when we get to our 5th session, when we do the breakdown of a case. It's basically reverse engineering too, how you write cases or how to break down the cases for mediation preparation. We do the mediation preparation. Then we'll also give the timeline and stress how all the parts fit together. Our opening statements we did in our second session, our last one there, the opening statements of the mediator and the advocates and clients. So that's basically setting the table, the ice breaking, the parties just getting into the room, establishing some sort of rapport and feeling each other out that this is a safe environment. So now, once the conference begins, that's our next step in the process. The conference, now the ball gets rolling toward a resolution, hopefully. Everybody sets the table. Here's what happened before we got here. And now we have the opportunity for all the parties and players in one room. And it basically conference, again, we'll start out now as a conference. Let me see our slides so Andrea's going to click them on. You can do the next slide, please. Thank you. Okay, what is a conference, first of all? Again, conference by its definition, all the parties. So it's basically everybody in the room. So you saw our diagram of the six chairs, if you will, the 2 mediators. We have co-mediators, the advocate and the client. And remember, advocates can be lawyers or they can be parents or other party acting on behalf of another individual. And then we have the 2 sides. And generally, when we have the layout, it's nice to have that general layout, because when you have judges in the competition, you need to know who's who. So when you're scoring the left side, team A or team B, they actually score the right ones. Oftentimes, judge over here is scoring the wrong team because they're sitting in the wrong seats. So that's a housekeeping process that we do when we do the tournament itself. The host in the room will make sure everybody's in the right places, so you get an idea where they are and what they sit. So the conference, everybody's in the room too. Now this is something, again, recall that mediations are all negotiations, not the other way around. This is a type of negotiation, a unique type of negotiation where you have the neutral third party. So that neutral third party, as I say, works for both parties. And again, we'll see at the respective roles we spoke about last time a bit in the opening statements. We'll see the roles of the parties here too, the mediators and the advocates. So definition, all the parties in the room, mediators, clients, advocates, discussing the issues at hand. Purpose, open communication. Really, conference is communication, hopefully productive communication. Sometimes it's steam blowing off. It's like, get son of a gun, here's what I feel, you ruined my life, whatever the scenario, the factual scenarios may be. So there's a bit of venting in there too, which is healing. Sometimes it's the first time parties have been able to actually see the other party. Say auto accident. The day of the accident, the other party didn't get out of their car. They said, hello, no, how you doing? What's going on? I'm sorry, what happened? I hope you do okay. Nothing. So oftentimes the parties will be there. Hey, part of the reason cases haven't been resolved oftentimes is because there is this feeling, personal feelings. You disrespected me. You don't care about me. If it's an employer or an auto accident, you walked away. I was there bleeding on the street and just walked over me and went home. So some of these personal issues come out. This is the time to do it in a productive manner, not where they get up and want to hit each other over the head. Not this, but again, conciliatory. Mediators and the advocates. The advocates influence their clients also. It's a respective role. So the conference, open communication, dialogue amongst the party. Views, concerns, potential solutions. They can also bring up a little bit of the solutions, what they're looking for. Generally, generalities, everybody knows at the conference what, here's a demand. We want X dollars. Here's what we offered. So that's their opening positions, their posturing. We have a strong case. We're going to win. Everybody comes out in their game face and posturing that, yes, if we go to court, we're going to beat you. Nobody wants to exude weaknesses in their case or their abilities. A lot of egos in the room too, the attorneys and others too. So nobody wants to be weak. They want to let everybody know it's like prize fighters getting up there the day before the fight, nose to nose, and they want to like give them that I'm going to beat you to death kind of attitude, that posturing, if you will. Strong scenario. So the conference generally it's an exchange of information. Components. Next slide, please. Thank you. The components, different parts of it. Timing. And usually when is the conference there? Here we have 1 hour settings for a mock mediation, first of all. So if there's no general guideline, that's why I have the timeline. I say reference that all the time. And I suggest the parties in the room, the parties and the judges should have this too. So everybody has a standardized general overview. Otherwise, there's not enough time for the students, first of all, to exhibit their skill in mediation, the parts of mediation. And if the parties aren't performing one of the different parts of the mediation, then if they're not doing it, the judges can't evaluate their skill level in that area. And it helps the parties if they keep going on, they lose focus. They look, oh my goodness, we only have 5 minutes left, and they try to wrap it all up. Gives everybody a little structure, which is good. In a loose structure. So the timing, generally opening statements. That's everybody says their piece a little bit, kind of frames the issue, who's who, what's what, here's what we're all about. And then right after that, everybody's in the same room. So that's the conference. You're in the room already instead of coming in and out. Afterwards, when we deal with the caucus next week, we'll discuss that. That's when one party and the advocate leave the room, and it's a separate conference, if you will, with the mediators. But the conference here is the exchange of information, ideas, feelings, emotions, whatever the case may be, put it on the table. That's helpful. It can be helpful if it's done the right way. And the mediator's role to tone them down if it gets a little too heated. If they get toward the edge, pull them back from the edge a little bit. Again, this is a negotiation. The parties have had an opportunity, a year or 2 years, who knows, opportunity to resolve their differences, but it hasn't happened. So what's different here that we're doing in this negotiation, which is the mediation, which is a negotiation, we're setting an agenda. Otherwise, there's no focus. You only have a limited time for the mediation. So agenda basically is key issues. What really are the issues that they're on the table today? What are the areas of agreement or dispute? Sometimes part of the agenda is that we've both agreed that some money must be paid. However, we don't know how much money should be paid. So there you refining what the issues are. And again, when there's a discussion, the agenda setting, mediator is the guide. So the parties will come in and try to set their own agenda quite often. I call them agenda stealers. In this level, you don't get the trophy hunters that try to manipulate the system. But in real scenarios, parties come in, they want to be the alpha dog, say, these are the issues. That's the only thing we're discussing, A, B, and C. Well, the other party may have some differences of what the real issues are too. So the mediator, again, you're mediating even the agenda, if you will. So what it was a mediator, one party is say generally the plaintiff, the person who filed the lawsuit, who's leading to, you call them plaintiff here, generally speaking, they come in and say, well, here's what they speak first. Here's what we want to discuss today. They have a general information sharing session, if you will, and then they focus. Now, here's what we're really concerned about: money, influence, respect, privacy, confidentiality agreements, whatever the major issues are. And when you look at your general facts, it'll lay out the general issues that are out there. When each party has their confidential facts, again, those are like the down cards in poker, if you will. Those are the ones only they get to see. Those are the agenda items that they really want here too. How much or little they disclose, it's up to them. And that's how judges evaluate your skill level. You don't just say, here's all my agenda, and just show all your cards. Then you've given your opponent an advantage. So no, so part of their agenda, if they see their confidential facts and they say, and we're really concerned with confidentiality. Our restaurant here, we don't want anybody to know there's allegations about poison in our food or whatever the case may be. So there might be an agenda there. So that part of it, you're setting the table on the agenda. You don't want to reveal too much. these are the issues. And I say, especially with it, excuse me, with an hour mediation, you can't have 48 issues. Otherwise, all you're doing is you're getting an agenda and nothing ever happens. 3 to 5 at the issue, under 5, 3 to 5 issues perhaps. And the cases are written where there's 3 to 5 general issues. Sometimes those can be refined. Respect, employment, the mediator can say, well, A and B here look pretty much the same. Why don't we put those on agenda item number 2 here? So the agenda said, and how they do it, practically speaking, again, what's in the room? If there's a whiteboard, blackboard, pieces of paper, they can all use it. It's everybody available. They don't bring their separate information. And they have a pad of paper. They can say, okay, agenda item number 1 is money. Agenda item 2 is apology. So they can use it like a piece of paper, or somehow the mediators can use it. They all agree then somewhere along the line, sooner rather than later, the agenda that's setting the table. Here's what we're going to be talking about. And everybody has an opportunity to create this. And the mediators clarify it. Their skill level is like, okay, do you agree, Bob, here? Do you agree that that's an important thing to you? Do you agree that Mary over here? Yes. Okay, that's our line item number 1. And there you're actually getting the parties to come together. If they can't agree on an agenda, you're not going to agree on a solution down the road either. So the mediator gets them to work together incrementally, everything incremental, little by little. So again, agenda setting, eventually they set the table. They exchange information too. The venting and clarification, feelings, frustrations, clarifications to mutual understanding. Party A will say this. And again, could be the attorney, could be the parties. It's a free for all in a way. Once trust has been established a little bit, the parties are more free to talk and even can discuss with the other attorney from the other side. In the legal profession and mediation or in trial, one attorney never gets an opportunity to speak to the other party's client unless you're in a deposition or they're on the stand in court. It's a breach of confidentiality. You can't do it. You can't communicate with the other party. So much of trial work, the adversarial style, impedes communication. The mediation format encourages communication, and it's a key aspect of the mediation, which you don't get anywhere else. Now, should be done in a way respectful and courteously. If I'm an attorney with the client next to me, I wouldn't like the other attorney to come in and just start talking to my client, Bob, over here. Bob, what about this? What about that? What's your bottom line? Generally speaking, you would do it, and this is the skill level, which is not to be expected too much at the level, but sometimes it's general courtesy, if you will. Doesn't even need to be professional, but ordinarily, Bob, you don't mind if I talk to your client you're married to? I'd like to ask a few questions. Well, okay, thank you. So it's being courteous to everybody, that rapport, respect, and trust. So that everybody knows it's safe. Okay, you're not trying to trick my client. It's safe enough. Well, go ahead, Bob. Tell them really why you don't want this. Tell them why the widget, your factories are good or not good, or what you do to make sure that all the widgets are the best widgets in the world. So there's a safe level, and you do it with the other parties cooperatively. Everybody plays the game. Nobody wants to be sitting back, not letting them play. So venting, clarification, and clarification, good mediator always clarifies. There's one party will say one thing, one party will say another thing. It sounds like they're saying the same thing or not, but in their mind, they're saying something and maybe meaning something else. So the mediator, if there's a agenda item or anything else, okay, now here's what I've heard from the two of you, and I want to make sure that you both are on the same page here. You said blue, you said green, but you're willing to compromise. Is that correct? Is that correct? So if there is an issue, you're making sure you're not going down the wrong path. Because oftentimes people think they've heard something from the other party and they interpret it in a different way than it was intended. So clarification is always one of the major tools for a mediator. Next slide, please, Andrea. Continue. Information, some of these I went over. Again, here's our diagram again too, not only for, in the competition, obviously we have 2 spots for judges there too. This is traditional. And the 2 mediators, A and B, and they work together, but they're in separate teams. As you recall, we'll go over a little bit. Advocate client, traditionally the advocate or the lawyer type would sit closer to the mediator. Not necessarily set in stone, but in these scenarios, it's best because I find to the judges, if the advocate is closer to the mediator, or to the judge, they assume the other party's the advocate, the other party's the client. So in their mind, they can say, okay, this is the role. Here's a script you have, and this is a stage. You're playing the role of the advocate. Generally, you sit closer to the media. That's how, in an ordinary scenario, in reality, that's how it would be, because the advocate, that's their home court. The client hasn't the familiarity with mediation or all things legal. So they're still protecting their client, doing their job, guiding them and advising them. So traditionally, that's how it would sit. And it makes it easier for the judges to make sure who's who when they're grading A and B and C and D here. Skip. So we do information exchange is good to do. And again, this is not much. Most of the time, there's been a good amount of negotiation, information exchange, but in a formal setting, not directly. It's the client speaks to their attorney sends a letter or a phone call or email, whatever it is, to the other party, goes to that other party's attorney. That attorney, in fact, goes to their client. It comes back and forth. And we all know if you tell a secret to 10 people up and down the room, by the time it comes back to you, you don't even know what it is. So it's like when it goes through too many people. So you have efficiency here where the communication is direct, and you could read the room. And instead of just that cold yes or no in a piece of paper, you go to heck, we'll see you in court. You could read the parties. It had a strong yes or no. Are they hedging their bets a little bit? Maybe I'll give you. You can read the party in the room in a personal level. In this day and age with remote, now we're doing in person, but remotely, same thing too. You try to read the room, and it turns out it is effective. I prefer most of the time to be in the same room when you're doing mediations, but not necessary, because you can kind of read the room too. But generally in the same room, you get a little more, the poker tells, if you will, to kind of read the tea leaves a little bit too. That party's nervous or what their level is. So that's another distinction between remote or in person, if you will. Information exchange, which is good. And the questioning, you can ask direct questions. The parties can ask questions. Well, why won't you do this? Why won't you pay this money? Well, you told me I'm a no good son of a gun. I saw it in the newspaper. You told the newspaper I'm the worst human being in the world, and they never do business with me. That's affected my reputation. Why the heck would you do that? So then there's an opportunity. You could say, you know what? I was mad. That was wrong. In power of the apology. So in the conference, you also have the ability, especially if you have a party who is egregious, they're wrong, and it's all about how much money they pay. It helps sometimes to say, you know what? We were wrong. We can't just give you everything. We're here to make this right as best we can. So yes, we apologize. My delivery driver ran over your uncle and killed him on the street. It's horrendous. I can't even imagine how you feel. However, we're here because of the process with my lawyers and insurance companies and everything. We're here to find out what the reasonable resolution is. What's a fair resolution? We don't know. That's what we're all about. And we're here, that commitment to the resolution. We're here to see what that looks like, what fairness looks like. A lot of people too, it's not right, it's not fair, it's just not just. So oftentimes techniques are, well, what does just look like to you? What's fairness look like to you? What's an adequate number? What's an appropriate sum? And that's where you dig in deeper into just sort of concepts as to particulars of what will get to the resolution. Resolution, I always say too, where you're going, it's more of a direction, a guide where you're going. It's not a finite location, if you will. So everybody comes in with the concept, this is what I want, this will make me whole again. But through the mediation, they don't realize maybe this instead of that, the creative solutions. Status of the offers, again, briefly, here's where we are up to here. We offered this, you offered that. You're setting the table, we're in court. We have 30 days to get this resolved, or that we're going to trial. Where we're at legally, information in the opening statements, they set the table a little bit on that. But just to make sure and clarify, is that true that most of you said you won't give them a nickel more than 10? Is that correct? That's what you said. And I'm assuming that's not a hard number there. That's where the mediator starts working. Well, we respect that. That's prior to today, that was your position. Perhaps if everybody has an open mind, we'll come to some resolution here. Maybe you'll bump off of that. Maybe you'll realize there's something else so you can get here. So you get people to kind of commit. Okay, I'll listen without moving. And that's also critical here. Where I'm saying status of the offers, demand, where you are setting the table, is the is the mediator in the initial, I say in the initial conference, that's right after the opening statements, before you have caucuses, which we'll get into next week. And that's a key issue. Not a key issue, but a key component of mediation where you don't get anywhere, the private conferences. So right now, in the first conference, they've had information exchange. I suggest the parties don't bargain or negotiate because they've had every opportunity in the world up to today to do that. And what's changed? Nothing other than the fact they're in the same room. Okay. They haven't availed themselves of the benefits of mediation, which is the confidential caucus. So the negotiation is not right. No negotiation or settlement before it's time. It's best after the caucuses when the parties have been able to reevaluate and exchange further information. So the negotiation, sometimes the party will say, yeah, you want a 10? Okay, we'll reevaluate, we'll give you 12. But we want to hold on to that because you're getting ahead of it a little bit too. And the mediator can say, you know, I understand everybody wants to negotiate here. However, and they encourage them, they guide them. I think it will be best that we finish our conference here. And then when the parties have an opportunity for the private discussion, we call it caucus here with each one of you, so I can get a better feel and you can reevaluate perhaps after you've heard all this information from the other side. And then after we come back after that, then we'll try and discuss this. Next slide, please. So this would be second conference. In a 1 hour mediation, you're not going to have time for multiple conferences. Generally the first one, and you have to have the meaningful conference, and that's generally the first one. And it could be a shorter one, but then the second one really has to shine. But again, you have to have a meaningful conference. Otherwise, we cannot evaluate their skill level if we don't see them do it. So the suggested amount, I believe we have is 10 minutes for a conference. That's everybody's there exchanging information, agenda setting, and eventually negotiation in our second conference. So we have disclosure, agreed information. So after, again, second conference would anticipate you've already had a caucus. The mediators a caucus with one party separately, they caucus with the other party separately, which we'll handle next week a little more. So now they've had some new information. Now the mediator has seen as many of those confidential facts, the confidential cards, as the parties chose to disclose. They don't have to disclose any, but if you want to avail yourself of the benefits of a skilled mediator, they certainly should discuss some things. And we'll get into the caucus next week. Okay, now you know this secret fact or this secret fact, these concerns that I don't want to let the other party know what's going on. First conference too, one thing I was going to bring up too, the mediator should be careful not to advocate or put one party or the other on a spot. Not say, well, they offer 10. Why don't you take 10? If you start acting like you're working for one party or putting them on the spot, in the caucus later, you can ask them, well, why didn't you respond? That seems reasonable to me. You can ask them there, because if in the conference, everybody's there. If it looks like you're showing a weakness or you're supposed to be balanced, if you're leaning toward the other party's not going to trust you at all. You talk about trusting the party, but again, you have to act, you have to earn the trust by your actions. And if you start evaluating, sometimes a mediator will start, well, that sounds pretty reasonable. They offer this, why the heck wouldn't you take that? Now you're basically advocating for one party. You're not working for both. It has to be balanced. In the conference, that's another story. You can get to the heart of the case. However, and we'll talk about that later. So after the caucus, now the mediator has some information from you, what you really want, what you don't want, what you particularly concerned not letting the other party know, also what your weaknesses or what your concerns are. And now you have some information. Generally, when you leave a caucus, the parties say, okay, now that I've told you that, Mr. Mediator and Ms. Mediator, here's what I want you to express to them, or I. So sometimes the messenger could be the mediator. Here it is. So that now I met with both parties here, and I have this information that they want me to say. They would now offer A, B, or C. So you can do that directly, or the parties can say it. Now, after meeting such and such, here's this new information that we have. We want to tell you now, here's what we're concerned about. We will move from this, we will move. So you're really in second conference, you're moving toward the negotiation with new information and clarifications. And the clarifications, now the mediator has met with both parties. And the mediator can suggest, you know, it sounds like I met with both of you and I'm not going to share any private information, But it sounds like you're not that far off. You just conceptually are in a different place. So I think both of you, and again, instead of suggesting, here, I'm the mediator, I'm going to tell you, here's what you should do. This, no, I think the two, now in their mind, the mediator knows you're close, you're far, and some oftentimes they're kind of close. Their brackets are a little close. So you can push them in the right direction, not tell them that, hey, a couple more dollars and they're going to take it. No, because you're giving away the other party's information. So, I would suggest, you're not as far off as you think in this matter. So I think you should both maybe talk about agenda item number 2 more. If you resolve that, I think you might go a long way to resolving the whole matter. They know what the parties really want or don't, and they can nudge, if you will, the parties in the correct way without revealing confidences or working only for one party or against the other. So clarifications. Now, you all mentioned this before, mentioned that before. Now that we've had these conferences, let's go over point A and B. Is it really money you want, or is it the apology? Reevaluation of positions. Now you have some new information from the other party, some things that they've disclosed to you that you didn't know. Why didn't you offer more than $50,000? Because our insurance company our limits of our insurance policy are $50,000. So that's the bottom line that we can offer. Now we can personally pay some more money, but what are we going to get in exchange? So now they have the money, they don't. If we paid any more than that, we'd end up going bankrupt. Our company would be out of business. And we could pay you more, but we couldn't pay you right away. Now you get toward the creative solution. If we paid you $100,000, we could only pay you $10,000 a year for 10 years. Now you have a creative solution as opposed to just $100,000. And these are solutions you cannot get in court. And when you go to court and you get a judgment for $100,000, pay it or file bankruptcy, and they can chase you for all the money. Here you can have parties agree that, okay, you can take payments over time. So you craft a creative solution for works for the parties' respective interests, wants, and needs is the term everybody's used. The interest is a broader term, which I'm not a fan of. So what do you really want and what do you really need? Everybody wants $1 million, whatever the case may be. The mediator skilled one tries to understand and get the parties to really evaluate what really is their need, what satisfies what they really need. Is it money or whatever the case may be? So creative solutions. Here you get the creative solutions are endless. In mediation, there are no limits to what you get as long as it's legal and lawful. You can do it. The resolution at the end of the day is a contract between the parties, which is enforceable in court. Again, when you get past that, creative solutions, okay, maybe there are. We agree on A, B, C. Again, in our mediation competition, there's no evaluation, if you will, for settling the case. You don't get points. Okay, yes, we all signed it, we won. Because if there is, then everybody just settles the case, whether it follows along or not. Oftentimes, there's not enough time or information for them to finally do it. If it flows and they settle it, that's fine. And again, the facts and the confidential facts, the judges get to see them. And sometimes it'll say, you will settle this if you get this. And the other party will say, yes, if you can settle this for this amount, you'll settle it. So they have to, if they read the confidential fact, they should settle the case. And actually, some cases are written, these are a little more meaner case writers, if you will, they settle it where you cannot resolve the case. It'll say you can take no more than this and you can offer no more than that. So the cases are written where they can't do it. So there, when you in this scenario, we shouldn't have those. But in those scenarios, you evaluate them and what the creative solutions are. How close did they get? How close did they get to realizing what the issues are and disclosing? We can't offer this, or we can't do that. But they generally are written where there can be a resolution. So the resolution okay, we agree on A, B, and C. We're done. We shake hands. Let's move on a happy way. Or there's an impasse. We agree on some of these issues, maybe not all of them, in what we're going to next steps. We either resolve this. Here's what we're going to do. We can, we'll come back in 2 weeks. But then there should be clarification by the mediators and the parties. The mediator guides them. So what did we do or not? And that's where we review your agenda again. We did this. A, we agreed. Here's the number. B, we agreed. C, we haven't reached an agreement here yet. However, we need this other information. So we agree to get an appraisal on this case. We're going to have a doctor reevaluate this party and see if there's a permanent injury or not. Something else that you may need to be able to fully evaluate and resolve the case later. That might be, or the next step might be see you in court and the heck with you. Hopefully not. If the spirit of mediation is generally always leaves that door open to, if not today, let's commit to tomorrow. Maybe we'll think about it. Let's schedule another mediation a week from today, and we'll see if we can wrap this up and leave it on a positive note. But, pounding the fist, I see you in court and go to heck. Not the spirit of mediation. It's always leave the door open to possibilities of resolving it. Let's see. And our next slide, I'll finish these slides a little bit, so we'll leave time for questions. Again, caucus, conference, all the parties, a general discussion, anything goes. Again, generally it's confidential and mediation to the world or afterwards, but nothing is confident. If you say it to the other party, they know about it, they're there. When you talk in a caucus to a mediator, that's confidential between you, the mediator, and it doesn't get disclosed to the other party unless you agree to do it. Again, the conference, everybody's in the room. There's a little pie chart there shows the 6 parties are in the room sitting at the table. Everybody knows what everybody's saying and doing. Caucus, one party and their client, the party and their advocate and the mediator. And again, how we do it, we'll focus on this next week is how the mechanics are then. But it's just the one side, and it's a private discussion. And there it's trust has to be earned. The mediator should inform them. Remember, this is confidential. What you tell me, it doesn't go anywhere unless you authorize me to instruct me to tell the other party. And sometimes you do. Here's what we want you to tell them. We're truly sorry about this. We want to work it out. Or don't tell them this, that our main witness died. So we have to settle this. If we go to court, we're going to lose. They don't know about it. They'll probably find out about it later. So right now, if we don't settle this, our case going to court, we're not confident on. Or there may be some legal issues or timing issues. Sure, we think we're going to win this case 5, 6, 7 years from now and a lot of lawyer fees and time, but our business will be out of business by the time we do that. Whatever the concerns on it, may not always. Money is usually the top of the pyramid there, but it can be mixed in with other concerns, and that's where the real needs of the party come in. And here, we'll go to the caucus next week, but focus aims to foster dialogue. Conference, we're talking discussion, information exchange. One of the best advice is to parties in a conference, keep your mouth closed and ears open, generally speaking. The parties, you're there to pick the other party's pocket, so to speak. You want to know what's in those cards that are on the table, the down cards, the confidential information. You want to know, you want to get them to disclose as much as you can so you can evaluate what they have, what they want, what they have to give you, what they need that you have to give them in exchange to set up your negotiation. Caucus, private discussions. Again, caucus, we'll get into that, but it's private discussion. Nobody uses the term caucus outside of this or the Iowa primaries. So use collective problem solving. Conference too. In 2 conferences, I combined the whole general concept. But the first one, information exchange. Second one is it's setting the table agenda. The second one more is a negotiation, the problem solving, and it's the creative solutions. Strategic for negotiation and addressing sensitive topics at caucus. And that's how you really use your mediator in the caucus too. When the private caucus, we'll get into it next week a little bit, you can instruct the mediator. Here's what I want you to tell them. Here's what I want you to find out for them. When you meet them, I want you to ask them, why the heck don't you, why didn't you do this? Why won't you do that? Why won't you pay any more? Everybody knows you should pay more. So you can get them to be your messenger in a way too. Next slide, please. Role in the mediator. Let's see again. Here, I term I stress again. The mediator technically works for both parties, but does not work against either one of them. So in our conference, our initial conference, when you're with there, you don't want to present and say, well, you don't want to bargain for one party or the other. Like they offer 10 or 5. Sounds pretty reasonable. Why wouldn't you raise your offer? Why wouldn't you take that? Then it sounds like you're working for one party and against the other one. So judging does no good. It hurts actually too. Understanding does. A mediator role should be more understanding. understand the party's position. Yes, I understand you feel that way. Not evaluating. Oh, of course you would feel that way because they ran right over you. And it's judging. That's tipping your hat that you're evaluating the parties. Should guide the parties down the right path to reach the common goal. And again, the destination, what resolution is, everybody comes in with their own version of what their destination resolution looks like, and they haven't resolved it because there's two different destinations. And I like to put it, it's more of a direction as opposed to a particular destination. So let's go toward resolution. And that's how you mix up the possible resolutions and the bargaining, following rather than leading. That's in theory. You're kind of telling the parties in a way, if you're skilled at it, without doing it directly. Would you please tell me such and such, as opposed to tell me such and such? You have a position of authority, it looks like. People want somebody there to be the ringleader, if you will. The mediator is the parent person who guides the process. And again, some people struggle with that, and that's when I have an opening, I mentioned in the opening statement, a mediator, I suggest, should get the parties to agree to this process. Like our timeline that we have is when they have a recalcitrant party. No, we don't want to do this. No, we don't want to do that. But remember, we all agreed that we're going to do a caucus and a conference so that we can all understand, get everybody's positions out there. Pull that back at them again. Remember, we did all agree, and this is the process. So I can understand if you want a little more time or less within reason, but get them to commit to the process. Because if you commit to the process, you're more likely to commit to the resolution. You intervene at the right time. And that's a skill level. I call it the art of purposeful mediation, is that when you do intervene or not, if there's a productive discussion between the parties in the conference and bargaining, and you know what, I didn't realize it, I'll pay you 10 instead of 7. What about this? What about it? Okay, you kind of sit back. Every now and again it's a competition, so you want the parties every now and again to say something, otherwise you forget they're in the room. So every now and again, you can at least don't interrupt a good discussion, but clarify. I think that, again, not judging, but evaluating. And I think this has been very productive, everybody here, and you get to look at them. Yes, it is. However, I think now perhaps it would be a good time to clarify. Instead of now I'm going to clarify, here's what I suggest. It sounds pretty good. What I heard, you with Bob and Mary here, you're kind of close on A, B, and C. Now, is that what you really meant? Is that what you agreed to? Okay, clarify it every now and again. And then, okay, now let the games continue and let them productively go back and forth and discuss again. So I call them active or passive. And that's an art form, when you should be active or passive. Same thing, the role of the advocate with the client. How much they should intervene, how much or participate, how much their client should participate. Everything should be somewhat balanced and not stopwatch, finite balance. Next slide, please. Again, good medias, again, listens, asks, doesn't tell, and it's an art in itself. You're kind of telling them, is strongly suggesting sometimes if you need, but you're not telling. Nobody wants to be told. All right, here's what I want you to do. What's your bottom line? What do you mean? What's my bottom line? Why would I tell you? Especially you don't ask them that in a conference because you're putting them on the spot. Caucus, maybe, but you don't just tell me your bottom line. Well, is there more? Do you think you have more money in there that you could offer? You kind of get there without pushing them. So you guide them in the right direction, if you will, not pushing. Patience, you have to have patience. Again, get the parties. Excuse me, in the opening statement, try to get the parties to commit to having patience. This is a process. Believe me, it works. There's going to be frustration and you have some anger sometimes, but we're trying to get past that. Remember, goal is the resolution. What we're, again, even mentioned, it's not what you think now means resolution might change in an hour. Stay with me, if you will. If you will, it pays off. I've been around, it works, if you will. So trust the process. Can we all commit to that? There's the commitment again. Concern. I can see how you would be concerned about it. I can see how you would feel that way. I understand. Gratitude. Think not just, okay, wow, that's a great settlement offer you made. No, thank you for sharing it. That must have been hard for you to do after that accident, whatever the case may be. I can understand it's been painful for you to admit such and such here. Understanding, empathy, human empathy. You don't want to have a box of Kleenex and start crying a little bit. Professional detachment and professionalism is appropriate. Acceptance without judgment. Even if they come up with the craziest offer, you want $100 gazillion. Well, that's rather, unique, or something, or you could laugh it off. Sometimes it's too crazy, whatever your particular skill set is, or what is your take. But again, without judging, what are you crazy? That's never, no, you never get that. No, that's judging. Then you're dismissing them. If you want people to trust you, you have to understand. Well, I understand. Some people might think that's a little high to say the least, but let's go and we'll see what they respond to. Again, confidentiality. You talk the talk, you must walk the walk. When you explain the process about confidentiality, you have to do it. If you're in a caucus with one, you don't say, by the way, I think they would go a little higher there. You don't want to tip it off, because if you're disclosing their confidentialities from the other room, they can't trust you with information, because then you might be telling it to them. So you have to act the same way that you'd instruct parties. Okay, thank you. I think we're done here. Questions, perhaps? Want to stay in our 45 minutes? I know your time is valuable. So anybody, if you have questions, you get shouted out to, if you will, or chat through Andrea. And John Arnett, I see he's there too. So we wanted to say hello to John Arnett. He's coordinates these mediation competitions. This will be the third one also.
Hello, everyone.
There he is.
Oh,
Okay.
sorry, I've got a silly background going on right now.
Good.
I just came on camera real quick. Draw your attention to chat. I put the link to where you can register a team or teams for well, you can register one team right now for the mediation competition. And you'll have a chance in that registration also to indicate if you have more than just one team that would be interested in participating, and then we can follow back up with you after the initial registration period ends to if there's more open spots. So I'm going to also just really quick put my email in the chat so that anybody who has questions about the kind of logistical side of the program, whether that's registration or anything with the website or how exactly the competition's going to work, you can feel free to reach out to me. So thank you all for being here.
Last thing I'll say too, again, to keep the parties haven't been to one of the tournaments. It's transformative when you see the students from the first one to the last one, the confidence level and the interest. They look and act the roles by the last mediation there. They learn from each other and hopefully from some of us and the judges too. But it is it's rewarding to see. And sometimes as educators, you're talking to the wall sometimes too, and it goes over their head. You'll see them; they will learn during the process. It'll be transformative as the goal, as I say.